On this occasion, we've got the huge privilege of having Joachmin Bornkamm, who has guided Germany's trademark law and then European trademark law with a firm and rational hand. Some of us would wish that he was on the European Court of Justice and that those who sit in the Court of Justice sending references to him. But it's not the way. And so he, like any other national judge, has to sit and puzzle with what the court in Luxembourg appears to be doing. We can't always say that we know what it's doing because it's sometimes so obscure that we don't know. Joachim has chosen what it is, in some extent, a technical subject, but it's also a non-technical subject. And you can see from the title, Community Trademark, a Swiss Cheese. Some of you might have thought that if you have a community trademark, it's enforceable across the community, you get damages across the community, and that's the end of the case. But we're going to be told it ain't so. Joachim, I know that the more I talk, more drinks are put back, so I'm stopping now.
Ladies and gentlemen, Stisha, it's a great honor for me to be invited to give this year's Sir Hugh Laddie Memorial Lecture. But it's not only an honor, it's the deeply felt need to pay tribute to the colleague and friend Hugh Laddie, with whom I had many memorable debates in front of fellow judges from all over the world. I was impressed by his sharp intellect, which kept me always on my feet, by his spontaneity, by his amiability, by his talent to capture your attention when explaining a complicated issue, and by his gift to make complicated issues simple. And I felt very much honored by his friendship. We met for the first time 15 years ago, in June 1998, at Singapore Airport in the lounge of Royal Brunei Airline, of all places, being the only guests waiting for the connecting flight to Brunei, where WIPO had organized a conference with judges from Asian countries. I remember one of my first impressions was that when we arrived at the airport, Hugh was surrounded by young solicitors, lawyers. And they didn't ask for his signature, but close to. You're the inventor of the Anton-Pillow order. Of course, I knew what about the Anton-Pillow order. I hadn't known that Hugh was actually the inventor, and that credit was given for this by Lord Denning to him in his book. But I found out. The conference, as many conferences both of us attended, was great fun. But at the same time, hard work. Because you would contradict nearly everything I would say. As I said, his sharp intellect always kept me on my feet. Mostly, I should say, the spirit of contradiction was not driven by a different opinion, but rather by the experience that nothing is more boring than two speakers who always agree. Hence, sometimes he would later tell me that in one point to which he had contradicted vividly, I had actually convinced him. Surprise. One contentious issue we had discussed was, for instance, the question how permanent injunctions in patent cases should be worded. I had submitted that this injunction should not just order the respondent to refrain from infringing patent X, because this was something not in dispute. The injunction should rather describe what exactly the respondent was restrained from doing, hence describing, for instance, the act which was considered to be an equivalent infringement. So once the discussion was over, in which you had articulately contested my submission, he asked me to give me some German case law, which he could use as a reference in a judgment. I sent him a couple of older German decisions, translated into English, and he used them among other references in a judgment in which he showed that indeed in an injunction, respondent should be told exactly what to refrain of. I should mention that my contribution to the advancement of English law was not successful in the end. The Court of Appeal overturned Hugh's judgment, not really giving reasons why you, and I for that matter, were wrong, but rather claiming that things should be handled in the way they'd always been handled. I should also mention that this is a very particular example how judges in Europe work together. And it's true not only for me, but for many other colleagues in the IP field. And this cooperation, it works with the English judges really in a very excellent way. And it's, for us, it's second to none. It's enormous pride that we see that our judgments, even though written in a foreign language, are of interest to the English judges. We can read their judgments, but for them it's more difficult. But we see that this dialogue takes place. And this is true for the judges who are here tonight. This was certainly true for Hugh Laddie, who was always interested what we decided exactly and the reasoning, and he made use of it. Before I come to the community trademark, just a word on the title. The community trademark is Swiss cheese. I do not claim copyright for that title. When discussing the topic, I sent Robin an email telling him what I wanted to talk about. In a couple of words, a little bit more maybe. But that's what I was missing a sexy title. As a rule, titles to legal articles are rather boring in Germany, while in the UK they often come with a pun. Within minutes, Robin came back with the title of the community trademark, a Swiss cheese. So he is the author for the title. Now, let me first say a couple of words to the function of the community trademark. This is the outline, and questions to be answered in an overview, and then 4 questions answered by national trademark law, and then we want to look at the same question answered in community trademark law. So the first bit is on the function of the community trademark. National trademarks, as any other national registered intellectual property rights, do not go well with the internal market. A national IP right is an obvious barrier to entry, a clear non-tariff trade barrier, according to Article 34 of the Treaty of the Functioning of the European Union, only justified under Article 36. Hence, on the long run, if we want to have a single market, we need a single European trademark, as we need a single European patent, a single European design right. Harmonization, in this case, does not do the job, as long as it is possible to obtain an IP right limited to the territory of a member state. Because goods branded with the German trademark may be traded anywhere in Europe, but once they cross the German border without the consent of the trademark proprietor, he may obtain an injunction. This is true for all rights which are nationally registered. With copyright being an unregistered right, it's different. Since a copyright work enjoys protection without registration, there's no need of a unitary European copyright. If the copyright legislation in the member states is completely harmonized, there are no barriers to trade anymore. a particular work will be protected all over Europe, and the same rules apply, so no reason of concern as far as the internal market is concerned. Therefore, it does not come as a surprise that the community trademark is a uniform right. And we look at the community trademark regulation, and there are very clear words in recital 2 to 4, and let's just go through this. It's desirable to promote throughout the community a harmonious development of economic activities and continuous balanced expansion by completing an internal market, and so on, and so on. In order to create a market of this kind and make it increasingly a single market, not only must barriers to free movement of goods and services be removed and arrangements be instituted which ensure that competition is not distorted, but in addition, legal conditions must be created and so on. Recital 3, for the purpose of pursuing the community's said objective, it would appear necessary to provide for community arrangements for trademarks, whereby undertakings can by means of one procedural system obtain community trademarks to which uniform protection is given and which produce their effects throughout the entire area of the community. The principle of unitary character of the community trademark, thus stated, should apply unless otherwise provided for in this regulation. Unitary character of the community trademark. And of course, this is the way our national trademark laws work. In Germany, the history of a unified Germany isn't all that old. I'm not referring to 1990, but I'm referring to 1871. Before, in Germany, you had many small states, and of course, once unified German state was created, it was obvious that any law which was IP law introduced after that was, of course, a law for the whole of Germany. It couldn't be to have one Bavarian law and another state and so on, because that would mean that within the one country you would have barriers of trade, of course, which you didn't want. So it is obvious that in one country you have one regime and the same rules apply, and that you have the unitary character in all the national IP systems, regimes all over the world. Article 1.2, paragraph 2 of the Community Trademark Regulation, it's not on the slide, which says a community trademark shall have a unitary character. It shall have equal effect throughout the community. It's the same words, but that's in the regulation itself. It shall not be registered, transferred, or surrendered, or be the subject of a decision revoking the rights of the proprietor or declaring it invalid, nor shall its use be prohibited, save in respect of the whole community. I stress this point, as you see, because I think this is exactly the point where of concern. It's obvious from this starting point that on the long run, national trademarks, national designs, and national patents should become obsolete, leaving the scene completely to the community IP rights. That's something for the, not the near future, but for the distant future. But it's, from the system, it's clear that on the long run, if you want to create one single market, you would have only one regime for each registered right. Hence, community IP rights are shaped in the same way as national rights are shaped. They are unitary rights giving uniform protection in the entire territory for which they are created. The uniform right granted by a registered right differs from other rights which are created by use. Trade names, for instance, may have a limited territorial protection depending on the area in which they have been used. According to the unitary character of the trademark, such a territorially limited protection is not possible. You cannot have a German trademark limited to the state of Bavaria or to the city of Berlin, nor can you have a UK registered trademark limited to the county of Kent or the city of Manchester. Either the right is granted for the entire territory or it's not granted at all. The same is true for the community trademark. Either you are entitled to a trademark for the entire union or you are not entitled to a community trademark at all. Now, what are the questions to be answered? And this also gives you an overview for the further part of my lecture. What do I want to show? What is the question to be answered in my lecture? The question is whether or not the case law of the Court of Justice is still in line with the unitary character of the community trademark. I start with the answer. It is my point that the case law of the Court of Justice is not abiding to the principle of unitary character of the community trademark, at least in some points. There is a tendency to create community rights which are protected only in one territory, for instance, in one member state, but not in the entire union. In my view, this is a betrayal of the principles which underlie the concept of community IP rights. The community trademark is, in some respect, a Swiss cheese. But while the Emmentaler is designed to have holes, the community trademark is not. It's designed as a unitary right. Holes are alien to this right. I suggest that we look at 4 different issues. And it's the first 2 which I deal with a little bit longer, which make the point. The third and the fourth I include because it's a similar type of question which is being asked. So let's look at the questions we asked. The first is well-known trademarks. We all protect well-known trademarks. It's not harmonized, but it's an option for the member states, and they all made use of it. So the question with the well-known trademark, that's the first case of the Court of Justice, which brought up that concern I'm talking about, the Pago case especially. So this is why this comes first. So the question there is, where do I have to show reputation in order to fulfill the condition of a well-known trademark? What are the consequences if reputation only exists in a small part of the territory, meaning a small part of the union? The second is distinctiveness and descriptive character. How does trademark law take linguistic differences into account? Is protection granted for a sign which is distinctive and non-descriptive in one part of the territory, but is not descriptive and not distinctive in another? What about injunctions once an infringement has occurred? Does the injunction have to be limited to the territory where, for linguistic reasons, confusion is likely? Acquired distinctiveness. You are familiar with the system of trademarks that if a particular sign initially doesn't have any distinctive character, it can acquire the distinctive character by use. So the question is, again, where do I have to show for the acquisition of a distinctive character in order to be eligible for the registration of a trademark? Where do I have to show that I acquired the distinctive character? And that, of course, applies to trademarks which do not have an inherent distinctive character to start off with. And then genuine use. Where must the trademark be used in order to meet the requirement of genuine use? Let's start to look at the national law, and it wouldn't come as a surprise for you that I look at the German law, because I'm most familiar with that. But I suppose that some of the reasoning I give would apply to any national trademark law. With the well-known trademarks, it's in national law, it's well established that the reputation necessary for a well-known trademark must be known by a significant part of the public concerned. The trademark must be known by a significant part of the public concerned in a substantial part of the particular member state. Local reputation does not suffice. If local reputation exists, there is no protection as a well-known trademark in that particular area. Either reputation can be shown for a substantial part of the member state, or the trademark does not enjoy the special protection of a well-known trademark at all. Now we come to distinctiveness and descriptive character. How does trademark law take, as I question I already put, take linguistic differences into account? In national trademark law, the answer again is rather clear. A sign must not be registered as a trademark if it's considered to be descriptive by a substantial part of the public concerned. Obviously, linguistic differences do not play the same role within one member state than they play in the Union. But there are some member states with different official languages: Spain, Belgium, Austria, with the Slovenians, Finland, UK, Italy. I think you can add more. And in nearly all member states, there are different dialects. Take, for instance, the term Erdäpfel for potatoes in German. It's a term used in the dialect. The ordinary German term is Kartoffel, even though a substantial part of the German public at large may never have heard of Erdäpfel, and therefore tend to take it as being a sign of commercial origins, if they come across it on a package of potatoes. It could not be registered because it's non-distinctive and used as a descriptive term by substantial parts of the public concerned. Or take this, the second example I give. It's taken from a case which was actually on genuine use, but I just wanted to show how one would deal about that particular sign. This was a trademark for hotel services owned by a hotel on a North Sea island, Achterdiek. And a normal German wouldn't understand that at all. I think it's closer to English than it is to German, because in the Low German this means behind the dike. After or Achterdiek, behind the dike. Such a trademark, again, would be considered to be only protected as a picture trademark because of the graphical presentation of the sign, rather than for the word Achterdiek, because it's used by a part of the population as a descriptive term. So you get the protection, but you only get it for the picture, and not for the word. If the word is used, it would not be an infringement of that particular trademark. There's a judgment of my court dealing with a split understanding of the public concerned. The other cases are also split understanding. You have a part of the public who understand what it means, Achterdiek, behind the dike, and others who don't. But this was a little bit different. The Gazoz case. The claimant held the trademark Gazoz for drinks. Gazoz is the Turkish word for sparkling water or lemonade. The respondent sells drinks and food under the trade name Marmara to Turkish supermarkets. Among these, a lemonade with the word Brause, which is German for lemonade, On one side, it's the what do you call it? Around the bottle, you can imagine that on one side you have Brause, on the other side you would have Gazoz. And he sold it to Turkish supermarkets in Germany. There are quite a lot of them. And these supermarkets are not only frequented by Turkish people or people of Turkish descent, but also, more or less half-half, by other Germans who have no knowledge of the Turkish language. There's no doubt that the Turkish word Gazoz can be registered as a German trademark, although a not completely insignificant part of the German public, being either Turkish or of Turkish background, considers the term Gazoz as purely descriptive. But since the defendant had only sold that particular product in a Turkish market, even though German customers would come to that shop, we considered that this was still within the privilege of descriptive use of the trademark. And for instance, take this example. If you would have the same bottle being sold in an ordinary supermarket, it would have been an infringement, and we would have given injunctive relief, and the injunctive relief would not be limited, even though there may be a situation in which the same use could have been descriptive. So there's a split understanding of the public concerned, but it only comes into the game, into the play, by the privilege of descriptive use, which is a privilege in trademark law, which also applies. If you use a particular trademark, even though it's if it's protected as a trademark, and even though there may be a danger of confusion, if it's used in its descriptive way, then it's privileged. Acquired distinctiveness is, I said, there's a similar question which you have to ask with when you acquire distinctiveness. Where do you have to show it? And it's very clear here that you have to meet a rather high standard. But that's not a matter of concern to me, because this is quite similar in the European community trademark law, and there's no much concern that the case law differs on this point. And we come to genuine use. No nationwide use is required in order to show genuine use. I give you an example we decided just last year. It was the case Orion. And in this particular case, it was the trademark was Orion, and the question was whether it was used by the defendant. The defendant was a Plus, which is a German retailer with subsidiaries all over Europe. And this particular product, coming from a Hungarian producer, came into Germany, 2,316 television sets, bought by Plus, but they were stored in a warehouse in Germany and then were later delivered to Plus subsidiaries in Portugal, Spain, and Greece. And we considered that this was sufficient for genuine use. It doesn't have to be on the market for the consumer. It's certainly use of the trademark if it's imported into the country and then, if you wish, resold to the subsidiaries. Now, let's go to the community trademark law. And let's come to the first case of concern. That's the Pago Tirol Milch case. This was about a well-known trademark in Austria, but not outside. Pago, everybody who's been traveling in Austria may know the product. It's a product which you find all over it's a fruit juice, and the protection was for a particular green bottle. Tirolmilch produced a drink with a similar bottle. And the question in this particular case was not confusion, there was no confusion, danger of confusion, but the question was whether the well-known trademark Pago was being affected by this use of Tirolmilch. So the question was Pago being a community trademark, not a national trademark? With if it had been a national trademark, there would have been any problem. But being a community trademark, whether this trademark actually was well known in the European Union. The Court of Justice came to the result that reputation in Austria is reputation in a substantial part of the Union. The rules are the same, substantial part of the Union. But of course the outcome was rather surprising. Don't tell the Austrians, but it's a small country. What, 8 million out of 500 million in Europe? Substantial part of the Union. But it would have been very difficult for the Court of Justice, I see the problem, to say that maybe the UK, maybe Germany, was a substantial part of the Union and not Austria. But where are the limits? Malta, Cyprus, we even have smaller member states. Luxembourg. So the answer given by the Court of Justice was the trademark must be interpreted as meaning that community trademark must be interpreted in order to benefit from the protection afforded in that provision. A community trademark must be known by a significant part of a public concern by the products or services covered by the trademark in a substantial part. The same word as we use in all our national laws. And that in view of the fact of the main proceedings, the territory of the member state in question may be considered to constitute a substantial part of the territory of the community. So that seems to be sort of a legal fiction. Once this judgment came down, it was clear that this protection given to Pago could not be granted to the whole of Europe. Because if Pago had been used by a UK company in a way which was not confusing, where only the question came up whether it was a well-known trademark, and if you limited the protection all the way down to a small part of Europe like Austria, it is obvious to everybody that this means you're giving protection just for that particular member state. So you have a community trademark, a registered right, which in the end only applies in that one member state. And that's something which runs counter to my idea of a unitary character. Nobody claims that the Pago rules mean that if you enjoy reputation in a small member state, you get the benefit of a well-known trademark all over Europe. So this is the first sin, der erste Sündenfall. But there's a second, I must say. And that's the question about distinctiveness and descriptive character. Now, let me first explain something to you which you all may know if you're familiar with community trademark law. If you want to apply for a community trademark law, the particular word must not be descriptive in any official language of the European Union. So, for instance, there was a case, mattresses, Matratzen in German, could be registered in Spain, because in Spain people take Matratzen as a fantasy word. They don't understand it. Again, you do have a not quite insignificant number of third age people living on the islands in Spain, which do understand some German, but that's not sufficient. So Matratzen could be protected within one member state as a trademark, but you could not get a community trademark, and this would be true with any official language, even the smaller languages. And I should point out that there is a suggestion by the Commission to change the community trademark law and the directive at the same time. And there's a provision in this proposal saying that this rule, which applies for the community trademark, should in future also apply to national trademarks. So that would be a question which would have to be put into the directive. And the directive would mean that the national trademarks law would have to harmonize in this way that you only get a trademark if it's non-descriptive, distinctive in any member state of the Union. That would mean that Matratzen in the future would not, if that comes true, could not be registered in Spain. And I think it's a very strong step, because it means that the national trademark systems become much weaker. There's not much reason why you should have what's left for the national trademark regimes. Not much, maybe. But on the other hand, I see a logic in this, because, as I say, on the long run, on the very long run, the national IP rights have to become obsolete, and we have to have, for the sake of an internal market without barriers, we have to have unitary IP rights and no national rights anymore. So if this comes true, I think the member states will contradict, but if this comes true, this would be a further step into that direction. So I think this is logic, but you may not like it, but that's logic. It's within the system. What the Court of Justice does in Pago, and in this case again, goes the other way. Now, again, the details of this case, DHL Chronopost, are not important. It was a question on Article 102 on the sanctions. And the question was whether, if you have an injunction in one member state, if you infringement in one member state, is the injunction to be granted for that member state or for the whole of Europe? And the Court of Justice made it clear that if there's infringement in one member state, you get an injunction for the whole of Europe. That's logic. You would not, if you have a trademark infringement of a British trademark in one county, you wouldn't limit the injunction. If you give a final injunction, you wouldn't limit it to that particular territory. But then, let's look at this paragraph 40. Now, these are the strong words, which no reason to dispute them. In accordance with Article 1.2 of the regulation, a community trademark is to have a unitary character, having equal effect throughout the European Union. It may not, in accordance with that provision, be registered, transferred, and so on and so on. So the principle is to apply unless otherwise provided. So that's more or less the wording of that particular provision. Then we go on, and we read in paragraph 48. Accordingly, if a community trademark court, hearing a case in circumstances such as those of the main proceedings, finds that the acts of infringement or threatened infringement of a community trademark are limited to a single member state, or to part of the territory of the European Union, in particular because the applicant for a prohibition order has restricted the territorial scope of its actions in exercising its freedom to determine the extent of that action, or because the defendant proves, and this is now the important part, or because the defendant proves that the use of the sign at issue does not affect or is not liable to affect the functions of the trademark, for example, on linguistic grounds, that court must limit the territorial scope of the prohibition which it issues. The first part, the limitation by the claimant, is something quite obvious. If the claimant doesn't want more than an injunction for a limited territory, okay, you can't give him more than he asked for. I think that's the principle in civil procedure which applies in all our legal systems. But the other point I'm concerned with, if for linguistic reasons a particular use of the sign would be an infringement here, but not in another part of the member states, the injunction has to be limited to that particular territory. And this would mean, if you scope it like that you give limited protection to the community trademark to that particular territory. It goes to show that the philosophy behind these judgments, the two judgments I've considered, the Court of Justice, is that when it comes to the end of the day, the unitary character of the community trademark is not something really looked after. I think if you would take that particular case to any of the national legal systems, you would never come up with that kind of idea that's saying, okay, if you use a trademark and you find an infringement, that you limit it in this way to a particular territory. As I said, acquisition of distinctive character is, again, there you have to show that acquisition, that you have distinctive character in a substantial part, and of course there's no dispute that this means that you have to show much more than you would have to show for a acquisition of distinctive character in a member state. There's no dispute about that. There's no case law of the Court of Justice, but I would think the standards here are similar. I have no reason to believe that the jurisprudence of the Court of Justice goes into another direction. There's one final case I'd like to mention, which is the case Leno-Merken, rather new case. The two trademarks involved were Onel and Omel. They are similar. There was no question that there was an infringement if, in fact, the Onel, which was the trademark of the claimant, could stand up. But the question was whether there was genuine use. And with genuine use, again, you would have the same type of question. Would you take the standard which is sufficient in a member state, or would genuine use in the European Union mean that you have to have a more substantial use? The reasoning of the Court of Justice is that they leave the question very much to the national judge. This happens rather often. I must say I prefer that kind of answer to what I consider wrong answers. But of course, if you look at the function of the Court of Justice in giving guidance which enables the national courts to administer and implement the community trademark law in a harmonized way, it's not a success. And it's very clear from this particular judgment that the court, in fact, didn't give an answer at all. Article 15, it reads, must be interpreted as meaning that the territorial borders of the member state should be disregarded in the assessment of whether a trademark has been put to genuine use in the community within the meaning of that provision. So one would say, you don't have to count the member states, you don't have to say at least in half of the member states or something, that's of no concern. But then you would have expected that it still would say something about the economic effect in the whole of the Union. And there's nothing there. It says, the community trademark is put to genuine use within the meaning of Article 15.1 of Regulation 2007, that's the community trademark regulation, when it is used in accordance with its essential function and for the purpose of maintaining or creating market share within the European community for the goods or services covered by it. It's for the referring court to assess whether the conditions are met in the main proceedings, and so on, taking into account all relevant facts. Okay, we know that. So in this particular question, the question I'm concerned with didn't get an answer by the Court of Justice at all. What I'm concerned about, again, is the community trademark being something different from what the national trademark is in our legal system. And that's something which I think has to be put right in the long run. We have seen in some cases that the proposal made by the Commission actually is a proposal to change the law in points where the Court of Justice had decided in a particular way. Sometimes contradicting the results of the Court of Justice. So you see that there's a difference of the, if you may say, the lawmaker. Of course, the lawmaker is the Parliament and the Council, but of course the drafts are all come from the Commission. And you see a certain contradiction there. You see that there is a certain discontent within the Commission about the direction in which this is going. Well, thank you very much for listening to me. I hope it was not too special, trademark law, and I hope I haven't been too critical to my fellow judges in Luxembourg. Thank you very much.
Any questions or comments? Yes. There's a mic coming. Say who you are, would you?
Thank you. Neil Muttock, Fortis IP, private practitioner. I've just got a question on use. Do you have any feel for the economic size of use based on, say, German law that we would need to get to in order to justify the extent of use for a European mark?
Genuine use?
Yes.
Yeah. Well, I must say that I'm a little bit, I'm not really sure whether it's quite clear that when you come to well-known trademark and to distinctiveness, I would think that you cannot apply the same standards which you apply to national trademark law. You have to, there should be a sort of a different standard looking at the size of Europe. With genuine use, it has to be genuine. And we don't want to have trademarks which are not used at all. But I'm not sure whether the genuine use really needs to be, whether you really have to have a use all over Europe. No, certainly not. Whether it's really of a concern to the trademark system. If you look at it in the long run, if we would only have community trademarks and no national trademark laws at all, the question would be, should you do away with trademarks which now enjoy the privilege of, or the standard of genuine use? If you only had I'm not sure about that. As I said, this
I brought him because it's the same type of question. And I was interested in the answer, and the answer was more or less nothing. But I would consider this an open question. And I don't claim that, as I would say, for the well-known use and for the distinctive notes, the standard has to be higher. It doesn't necessarily have to. Okay? We are, in German law, we take it as a more or less to rule out abuse. So we are generous, rather generous. And if it's clear from the facts of the case that it's not a use which is only put up in order to keep the trademark alive, but if there is economic sense behind it, then that's sufficient. So this television case, I mean, it was actually only one transferal of goods. Of course, a whole lot of goods, but we didn't have any reason to believe why this was in any way an abuse of the trademark, even though it never reached the consumer in Germany. But the goods were sold to Germany, and within the concern, the group, they were sold on. So there was no abuse. I could imagine that you would even apply a similar standard even on the European scale.
Thank you.
Yes, Stephen.
Hello, Stephen Jones. I think most of the things that you were pointing out seem to me to reflect one of the big realities about the European Union. If you compare, for example, the United States, and you compare, as you did, United Kingdom, Germany, these are all big economic units. But the other thing that characterizes them in the main is that people speak one language mostly. Obviously there are dialects, and in some countries there are different languages within the same country, so there are exceptions to that. But mostly you've got a commonality of language. I think one of the things that the European Union is greatly challenged by, and this applies in all areas, not just trademarks, is the fact that we speak all these different languages. And when you go to Brussels or Luxembourg, you're surrounded by interpreters interpreting into all these different languages. And the realities of the cases that you refer to are, in general, that it's struggling to cope with how do we deal with the fact that in Spain there are people who don't speak any English, don't speak any German, have never heard of the word mattress or matratzen, and and then how do we deal with the fact that on the other side of what is now a community that's enlarging all the time, you've got these other languages which have those differences. And I don't see how. I'm a bit worried about the suggestion that you should somehow try and unify everything and make it not a Swiss cheese, because I think you have to allow for some exceptions in the scope. We've got a trademark registration with an immense scope of protection over all these 27 countries, and if you don't allow a few holes in it somewhere to accommodate for these differences of language, I think it would become a very difficult thing to administer. So I think what I'm saying is I quite like Swiss cheese, and sometimes, and this might not altogether be a bad thing to have a few holes here and there.
Well, I think your question refers more to the proposal of the Commission, which the proposal being that if a particular sign is descriptive or non-distinctive in one member state, it should be considered to be non-descriptive in the whole, or you don't get protection at all. That's a question you can dispute, obviously, because it would limit the possibility to get signs which are in a large part of the Union, no other reason why you shouldn't register them. On the other hand, of course, when these signs are registered, taking a term of a foreign language, there's quite a lot of, very often it's done well knowing that it's, of course, well knowing that it's a term, and having a certain use in mind. For instance, we had a three-dimensional mark for a Russian sweet. We didn't know that it was absolute. Nobody in Germany knew that it was something absolute standard. But of course, the only reason why this was registered, to keep the competitors who sold the same item out of the market. So very often in these cases, same with Matratzen, of course. Matratzen was directed against the German company Concord, Matratzen Concord, and they sell all over the place. And this was, in a way, I would say, quite obvious that this was the economic reason why such a word would be registered. So I wonder whether really this is such a limitation to the right of the of a undertaking, whether they really there's really need for that protection. But again, this is not my main issue. That's the proposal of the Commission. And my main issue is that once you have a community trademark, it should be granted for the whole of Europe. And you shouldn't have the idea behind it that you give it, but then again, you take it away again because you give it only to a particular part of the union.
I think that was the point I was addressing, really. I think it's the scope of the injunction. If you say the injunction should always be for the entire union, you may need to have holes in the injunction sometimes to accommodate.
I agree. There's one point I agree with you. The question is, the injunction is given under the circumstances of the case. And you can always claim as in a second case or whatever, that the circumstances of your use are different. That in your case, it was descriptive use. And then, or for instance, you get an injunction and then you use it in a different way, and in another part of the country where everybody understands it as being descriptive, then you could maybe claim that it's merely descriptive in this case. And you couldn't enforce the first judgment. That's part of our system, that a particular injunction or only works under the circumstances of the case decided. And you have a different situation, you may not be able to apply that prohibitive injunction. I agree. What I don't like is the idea of giving, sort of limiting in the first place, the injunction right away. Maybe this is only a question of semantics, but it comes along with this idea of limited, territorially limited rights, which I don't like, which I think the Court of Justice doesn't explain how it comes together with the unitary right. Yeah, this is what my concern is, that they paid lip service to the unitary character, and that's all.
Right, we've got one more, and here he is, as usual, but always precise.
Richard Arnold. I just want to ask how you square your theory with the express Swiss cheese provision in the CTMR, the number of which I don't recall under current numbering. It used to be around 110. This is the provision for rights of purely local significance, because the regulation expressly provides that you cannot have unitary character of the right in those circumstances.
As I said, it's the provision in 1.2 it says unless otherwise stated in this. And that's a case where it's otherwise stated. I should also say that the question, for instance, there is a provision in the CTM that if you have a community trademark, that's again as to genuine use, which you only have used in a part, and it's considered not to be sufficient, you could continue that particular trademark as a national trademark if it doesn't stand to the conditions. But that only applies as long as you have two systems running side by side. It shows that apparently, I'm coming back to the first question, that for genuine use there may be the idea that different use is necessary. But the particular, whatever, 110, I'm not sure either. But that's one of an exception which is expressly stated. And the other cases, there is no exception at all.
Just wanted to thank you again for an excellent lecture, very clearly explained. I think that there probably were many more questions in the audience, and I think that you will have an opportunity to ask some more questions over drinks. But I want to thank you for giving an excellent Sir Hugh Laddie Memorial Lecture this year. Thank Robin for his continued leadership of IBIL. To say my own welcome to Stecia and James Laddie, who are here this evening, to welcome everyone else. We always have wonderful attendance at these lectures, and I'm sure that you will agree with me. You've had a really interesting and valuable lecture this evening, and on your behalf I would like to thank Judge Birkin again.